Hello, everybody, and welcome back to SEC Roundup. I'm Nick Morgan, co-host of today's episode and co-founder of the Investor Choice Advocates Network. I'm joined today as co-host Mark Harady. Mark is ICANN's Senior Legal Director and Policy Counsel. Mark, thanks for joining.
Thank you.
And we're happy to get together in particular to talk with our guest, Amanda Rose. Professor Rose is a professor at Cornelius Vanderbilt Chair in Law at Vanderbilt University. And I noted, Amanda, that you were formerly at Gibson Dunn and formerly clerked on the Ninth Circuit, which is maybe appropriate since I'm sitting in San Francisco doing this podcast. So thank you so much for joining us today.
It's my pleasure to be here. Thanks for inviting me.
And the reason we have you on, of course, is to talk about a working paper you recently issued called Suing the SEC. It's put out under the auspices of the European Corporate Governance Institute. The paper is forthcoming. I think it's about to be published in a law review. Is that right, Professor Rose?
That's right, in the Texas Law Review.
Oh, fantastic. Congratulations. And given the fact that ICANN has on occasion sued the SEC, we thought your paper was super fascinating. Mark, maybe you can kick us off with sort of an open-ended question that lets us know a little bit about the paper.
Sure, Professor Rose. I'll jump right into it on the issue of the value of victory in litigating against the SEC. In your paper, you argue that one of the values of victory in suing the SEC has increased because judicial wins are now more durable and harder for a deadlocked Congress to override. That reminds me of the Supreme Court's decisions before the COVID pandemic in Kokesh and Liu that curtailed the SEC's ability to obtain disgorgement in federal actions, and then subsequently Congress amending the Securities Exchange Act of 1934 to expand the power of the SEC to obtain disgorgement actions. How does your rational actor model, that is the assumption that market participants act as selfish, rational utility maximizers, explain why defendants who for decades prioritized getting it over with through settlement are now finding it more rational to mount what had been expensive, high-stakes constitutional challenges against these longstanding agency practices?
Yeah, so that's the question I really want to answer in the paper. We've seen, and there's empirical data that supports a big uptick in the amount of litigation against the SEC beginning in the 2010s, spiking in the 2020s, with actually very little in the preceding decades. And so this project was an attempt to kind of think through what forces might be explaining that. And Mark, as you indicate, I take a rational actor kind of approach and say, well, let's think through what is the decision-making process of a market participant when thinking about how aggressively to defend themselves in an SEC enforcement action, or what type of maybe action to initiate against the agency. And I posit that you're going to engage in a cost-benefit analysis, essentially, which is going to involve weighing the value and the probability of a victory against the cost of bringing suit. And so one of the things that I note that has changed is the likelihood of Congress to intervene to sort of validate agency actions that are invalidated in court because of heightened partisanship in Congress. But that's, I think, really one of many factors, all of which are helping to explain why litigation against the SEC has become more attractive. So just kind of marching through the outline, maybe to set things up, and I would love both of your thoughts on this as well. So if we think about the value of victory is really reflective of the costs, the regulatory burdens that are going to be avoided if you win the lawsuit, right? Them being more durable because those victories will likely remain is one aspect of that, but also just how costly the agency action is to begin with is an important factor. And I point out in the paper that the cost of regulation went up in the 2010s, especially with the SEC's use of new enforcement authority. It went up under the Gensler Commission as well because of the scope, the burdens that new rules imposed, and also the regulatory techniques that were used. So you have, the value of winning going up because the costs of the regulatory burdens have gone up. And you also have the probability of victory going up as well. As a product of many different factors. So, to the extent that the SEC is taking more aggressive positions regarding the scope of its authority, those sorts of actions are going to be more vulnerable in litigation. So that's going to make the probability of winning goes up the more aggressive the SEC stance is. The sort of quicker and less well-reasoned rulemakings are, the more vulnerable they're going to be. And the pace of the Gensler era rules suggests that they would be more vulnerable as well. And then, of course, there's the backdrop of judicial precedent regarding agency authority. And so, decisions like the DC Circuit case back in 2011, the Business Roundtable case, imposing sort of heightened expectations on the agency to defend its sort of cost benefit analysis and rulemaking, made it the probability of victory go up. And then, of course, the more recent Supreme Court cases, Loper Bright, West Virginia versus EPA, also increased the probability of victory. So that's the benefit side of things. And then I also argue, and I can pause here and get your thoughts on those factors, but I also think that the costs have gone down, and there's some important components on the cost side to talk about as well, which help to explain the sort of increased combativeness of defendants.
Yeah, well, what you gathered and demonstrated empirically in the paper certainly rings true for us anecdotally. And on the last point, the cost point, we provide pro bono legal services to people in SEC matters. So it is, I think, in 100% of the cases where we approach someone and say, would you like to continue to litigate against the SEC if we do it for free? That changes the dynamic from, it's basically binary from a no, I don't want to litigate to yes. So at least anecdotally, in 100% of our clients' cases, that is the case. And in terms of, you mentioned some of the cases that might enable this increase in litigation, I might add to the list, because we're arguing about it right now, the Supreme Court's decision in Corner Post, which potentially expands the statute of limitations for challenging rulemaking under the Administrative Procedure Act. So we've got an active piece of litigation where we are challenging a rule not implemented during the Gensler era, but instead implemented in 1982. So Corner Post potentially opens up the range of rules that could be subject to that litigation. So, but I am interested, I cut you off, or you allowed us to interject. What is are there other factors on the cost side that you observed?
Yeah. So if we think about costs, we've got kind of the out-of-pocket costs of litigation, which obviously pro bono services like you're providing, especially to smaller and individual investors, can make all of the difference. That's, for other kind of repeat players in the market, there's also what I call in the paper reputational costs of taking an aggressive litigation stance against the SEC. The SEC has a lot of discretionary authority, and you might fear alienating your regulator by raising certain sorts of challenges. And I argue in the paper that sort of the growth in the private markets and the ability to sort of avoid entanglement with the SEC to some extent by engaging in private capital raising diminishes those reputational costs somewhat. And so these broader trends in the private markets may actually be playing somewhat of a contributing role in the increased willingness of companies to fight back against the SEC. The other category of costs I label competitive costs, which are, if a company is going to challenge the SEC, it's going to create benefits for their competitors as well. And so there's sort of a collective action problem that arises when you challenge a regulator. And there are groups that help to overcome that problem: the Chamber of Commerce, the Business Roundtable, and in the recent era, a growing number of organizations focused on assisting other pockets of the market. And so I think that has reduced what I call competitive costs, and that sort of all of these factors in combination reduce the cost of litigating. I also point out in the paper that there are certain frictions that make it hard for a market actor to engage in this cost benefit analysis. Sometimes there's huge informational asymmetries, especially when you're dealing with people who don't interact with the SEC on a regular basis, who rely on certain market intermediaries for advice, who may have conflicting interests from their own. And so that's another role that I think organizations like yours can help with, just educating market actors about what the legal vulnerabilities are and what the legal possibilities are. So I think that that's been an important factor as well. I also think the fact that companies are becoming public companies, bigger, more sophisticated in later stages, changes dynamics as well. There's less sort of reliance on the securities lawyers and, the investment banks and some of these actors that again may benefit more from the way things have always worked at the SEC. There's more sort of in-house maybe willingness to think anew about whether certain practices should be challenged or not.
That's a really interesting point. Oh, Mark, you
Yeah.
probably had the same reaction I did.
Yeah, I was just going to say, when we get replaced by AI, then maybe that problem will be mitigated.
Right. But I do think there is, I mean, I have practiced as a defense attorney at several very large firms, and I do think there is very often a desire on the part of the attorneys and compliance folks to advise potential defendants to settle. It's, as you point out, sometimes not rational on a reputational basis or other basis to litigate. And so I do think getting advice from other sources of information. I was speaking at a conference. I think it's an organization you mentioned in your paper, the Alternative Investment Management Association. So there are these different industry groups where they may help to solve that collective action problem and reputational problem, where the industry group takes action, which we did see in reaction to some of the rulemaking in the last administration. So that's an interesting development. Let me pivot for a minute. You talk in your paper about, you use the phrase de facto power, the SEC's de facto power. And oversimplifying a little bit, you describe it as a collection of levers, like safe harbors, conditional exercises of discretion, maybe no action letters, that sort of thing, that allow the agency to micromanage market behavior while eluding the transparency requirements of the Administrative Procedure Act. As the agency shifts toward what some might call bread and butter enforcement under new leadership, do you think the recent spike in litigation against the agency that often involves these soft levers has permanently forced the SEC back toward formal rulemaking, or will the agency simply find new, more subtle ways to exercise the de facto authority?
Yeah, it's a great question, Nick, and I don't have a crystal ball. So just to kind of back up a little bit, as I sat down and started trying to think through this, what really struck me is, wow, why hasn't there been, the SEC is so powerful and it does use all of these sort of questionable regulatory techniques that do tend to augment its power in ways that are not as subject to accountability mechanisms. Why hasn't industry pushed back more against these techniques? Why is there so little litigation until recently? In any event, I do think that the recent uptick in litigation, as well as philosophical changes in administration about the role of administrative agencies, is leading to sort of more restrained and changed techniques. So one thing we're seeing under Chairman Atkins, of course, is a desire to maybe move away from no action letters, like in the 14A8 context, to rely more on formal rulemaking and less on some of these discretionary techniques, like, for example, sort of conditional exercise of acceleration authority, and these are the sorts of levers I'm talking about. How permanent will that be when you have an SEC chair that has a different philosophy? Well, I guess it depends. Simply saying as a matter of policy we're not going to rely on no action letters is something that can be quickly and easily reversed in the future. Formal rulemaking is more cumbersome to reverse. Obviously, congressional intervention is going to be the gold standard for having some sort of durable change in the way the SEC interacts with regulated parties. And I think Chair Atkins recognizes that as well, and would call on Congress to, for example, maybe intervene in certain areas to clarify what the scope of the agency's authority is.
Yeah, actually, we just saw that happen yesterday, today, on the rulemaking around public company disclosures of climate issues, where the Atkins administration is seeking to undo some prior rulemaking on that subject.
It's really important, I think, Nick, also because, as things are more partisan in the world, these discretionary levers have become, I think, more problematic for market actors, because it's one thing to have an agency exercise discretion in sort of a predictable way towards sort of stable goals. It's another thing when you have really rapid changes in how that discretion is exercised and kind of policy flip flops. And so that makes the use of those techniques more costly and more attractive to challenge legally. And I'm not sure that the way the SEC has always done things is something that's actually sustainable in the moment we're in the new political environment that we're in.
Yeah. Yeah. Mark, I realize I think I stole your third question. So if you had I have another question I want to ask, but I wanted to give you an opportunity to maybe pose a different one since I cannibalized your.
No, sure. Professor, on the role of new intermediaries and ICANN, your research highlights reduced frictions as a major driver of recent litigation surge, specifically noting that new interest groups are helping market actors overcome the collective action problems that historically made suing the regulator too costly. From your perspective, how do you how do specialized advocacy organizations like ICANN fundamentally change the cost assessment for smaller market participants or individual investors who in the past were the most likely to be systematically disadvantaged by the SEC's regulatory rents?
Yeah, I mean, I think that it's a huge impact. I think I agree with Nick when you said it's sort of a binary for a small investor. The cost, the expense of hiring a lawyer is simply prohibitive. So having the ability to have pro bono representation, I think is critical. I'd also we talked about some of the important legal changes that have changed the probability of victory and also the cost assessment as well. And of course, Axon Enterprises is huge as well in terms of allowing you to more quickly raise your constitutional challenges in federal court. I mean, the prospect of having to exhaust years and years of an administrative battle, I mean, it's just irrational to ever do that. And so that I think is another really significant change that when combined with organizations like yours just makes it, it's just that the rational outcome is very different.
Yeah.
Yeah.
The companion case to Axon, of course, is Michelle Cochran versus the SEC. And we have become associated with Michelle and heard her story. Her story is incredible. And you're right. Like she went to federal court to challenge the administrative proceeding she was subject to. And the federal district court judge said, I'm sorry, you need to go all the way through the administrative process, exhaust that, and then maybe come back to federal court, although it would be not this court. And from the transcript, the district court judge seemed very sympathetic to her plight, but felt helpless to do anything about it. And then, of course, Axon and Cochran went up to the Supreme Court and granted access to federal court. So that definitely was a game changer. Let me pivot once more and ask you a question that hopefully is easy to answer. You talk about the public choice theory and complexity as a barrier to entry. Maybe for those who aren't familiar with it, maybe you could give us what is the public choice theory just in a nutshell, and what do you mean about complexity as a barrier to entry?
Yeah. So, public choice is sort of a lens for thinking about how regulators behave and how governments behave that starts from the sort of presumption that, governments or administrative agencies are going to respond to the interest groups that are able to deliver the political support or other benefits that a regulator consumes, and so looks at the production of regulation as sort of like a marketplace where the most mobilized, sort of resource advantaged and concentrated groups are going to have the most success in influencing government behavior. So it's one kind of academic lens of thinking about and understanding, it's contestable. Maybe that's not how agencies behave, but it's been a powerful theory that has been relied on quite a bit in the literature focused on the SEC. And what it would sort of predict is that these sort of strong incumbent interest groups are going to benefit from regulation, and that sort of more dispersed actors who have less leverage are going to kind of be the losers in the sort of competition for regulatory rents. And if you think about the way the SEC operates, some of the regulatory techniques that it has relied on throughout time that rely on a lot of discretion, some of the bigger groups may be able to navigate that and influence that in a way that smaller actors have more trouble doing. And so the actual regulatory techniques, as opposed, in addition to like specific rulemakings, may benefit certain larger incumbent groups versus sort of new entrants or smaller investors. And so just like but the securities laws are so complex and counterintuitive that along with sort of the costs of regulation more generally can create a barrier to entry, can make it harder for companies to go public, to deal with the regulatory morass that exists. So that wasn't a very articulate answer, but
No, I think it rings true for us. And since, the name of our organization, Investor Choice, one dispersed constituency, consumer of regulation is investors, in fact. And you might think that they were amply represented in the regulatory process, but in our view, it's not. We have an active piece of litigation challenging the accredited investor rule on behalf of an individual investor. And the regulations around accredited investor have been designed to protect people like our client who doesn't want that protection. So I think a good example of what you're talking about, where the regulators don't necessarily respond to dispersed constituencies that don't have the ability to sort of collectively articulate their point of view. So I thought it was a great point in your paper. Well, we'll leave it there. Thank you so much, Professor Rose, for coming on. Really appreciate this. This has been fascinating. The paper is available online, Suing the SEC. I commend it to anyone who sees this podcast. Mark, thank you, as always, for co-hosting. And to everyone else, if you want more information about ICANN, go to icanlaw.org. Thanks. We'll see you next time.
thank you.